Okay, well, good morning, everyone. I've got about 1 minute after the hour, and we will get underway. There might still be a few more people logging in, but we've got a lot of content to cover, so we will get going. I want to welcome everyone, and thank you for joining us today for our meeting on navigating the DOL Fiduciary Rule. My name is Tom Vukovic. I head up the Financial Products Division with Insurance Network America, and joining me today is our President and COO, Lori Beck. We have a terrific turnout today. I'm excited to see that. I see many familiar names that are with us. I want to thank you all for your partnership and for being here today. And as always, we are committed to providing you with great ideas and tools to continue to build your business, as well as provide timely information that you need to know about. Our focus today will be just that. At our Top Producer Summit this past August, Lori Beck and I held a session in an effort to communicate Insurance Network's thoughts and direction on the DOL Fiduciary Rule. Today, we want to repeat that message to all of you that might not have been able to attend our great summit in August. And we'd like to repeat that message and share any additional information that may have occurred since in an effort to give you what you need. And during today's call, if you have any questions, I want you to please use the webinar system here to submit your questions. We will do our very best to get to all of your questions towards the end of the presentation. If we do not, you can certainly expect a phone call to follow up and answer any additional questions you might have. So again, thank you for joining us. And at this point, I'm going to turn the call over to our President and COO, Lori Beck.
Hey, Tom, thank you. I'm not seeing the option to share my screen. Oh, there it is. Thank you very much.
Okay. Wonderful. Thank you, Lori.
All right, good. And I assume then you can see my screen at this?
Yes, I can.
Great. So I want to thank everybody for spending some time with us today talking about this new Department of Labor rule. You know, as you know, the final rule was released in early April of this year, and since then, I'm sure you're getting barraged with information. Not all of it is good. You know, we see a lot of the same communications that you see, and I'll tell you, some of it is downright scary, especially if you're an insurance-only producer. Now, at Insurance Network, we've been following this bill from the beginning. We have spent countless hours studying the rules, talking to industry experts, and our legislators. And let's be clear, as written, this rule will change the way we all do business. From carriers to broker-dealers, registered investment advisors to banks, plan sponsors, advisors, and organizations like ours, we will all have to change some of the ways we do business if this rule stands as it is today. And the message that we want to really convey to you is that we don't want you to ever feel like you're out to sea alone. And today, we want to talk to you about navigating these changes and doing it together. You know, and to do that, we want to give you as much information as we can and cover the most pressing things on your mind. We know from talking to many of you that your most important questions, assuming the rules stand as it is today, are how does this rule impact me and my clients? Which products are affected? How does this new rule impact my broker-dealer if I'm a registered rep, my RIA, my insurance carriers, and my IMO? What are my best next steps? A lot of you are getting inundated with, if you're an insurance-only producer, the fact that you need to become securities licensed. And the question that I hear from a lot of people is, should I make that change? And we'll address that a little bit as we go forward. Some of you are already working under a broker-dealer or an RIA, and you might wonder how this might impact you, and we'll talk about those things as well. And then, of course, you know, really, when will this impact me and my practice? You know, we're going to do our best to answer all of these questions the best we can, but please know that this does not stop here. This is an ever-changing rule and an ever-changing environment. And so we're going to continue to bring you updates as often as we can between now, the end of the year, and then as we embark into 2017. I wish we could give you clear answers on all of your questions today, but the truth is that there are still 1,000+ pages to navigate, 5 lawsuits to be heard, 3 different courts to decide on those lawsuits, a presidential election, opposing opinions, and many differing strategies. And all of this is happening rather quickly. In fact, we appear to hear an initial ruling on the NAFA lawsuit, the National Association of Fixed Annuities lawsuit, as early as next week. And with respect to that lawsuit, let me update you on where it stands today. You know, initially, each side was extremely confident that they would win this lawsuit. NAFA went out and hired the best of the best attorney firms out of Washington, D.C. The Department of Labor brought in Department of Justice attorneys to represent them in this court. And when you listen to both sides, they both acted like this was going to be, you know, somewhat an easy battle. I think NAFA was a little more conservative, but still they were very confident going in. Both believed that their case was 100% solid and that the judge would easily side with them. The actual hearing played out a little differently. It was clear from the transcripts that the judge was not going to let this be an easy conversation for anyone in the room. He asked hardline questions of both sides, but in particular, I felt he hammered NAFA a bit. And perhaps that's a good sign. I don't know. Perhaps he did that because he knows that to rule against the federal government, he must have solid reasoning. Many insiders do feel that he's going to rule against us, against our industry, which means that we need to be prepared for an immediate appeal. And we are. By the way, I say we because at Insurance Network, we're very involved with NAFA, and we're members of that association. In fact, I sit on the membership committee and have been nominated to sit on the board of directors beginning next year. It's an association that we feel very passionate about, and I'm telling you, they are fighting for you and the right to do business in this space every single day. And again, we expect to hear the judges indicated that we should have the initial answer back as early as next week. Given that I'm on an inside track with NAFA, I can tell you we already have the money in the bank to fund the appeal. And so if we lose, we do expect that. But if NAFA loses their lawsuit, there are still 2 other lawsuits, or actually there's one court down in Texas, which is 3 lawsuits that have been consolidated. And then there's another lawsuit that's been filed in Kansas. So this battle is far from over, I guess is the point I want to make. But despite all of the uncertainty with the lawsuits, we do have a good deal of information for you today. But before we start, I wanted to remind you that we've had to navigate around big obstacles to our practices before. I mean, in very recent years, we've had to battle 151A, the Affordable Care Act. These were 2 huge threats to our businesses. These were obstacles that could have sunk us if we did not successfully navigate them, but we did. And we have been able to weather each of these threats. And we're going to do the same with this one, the same way we did the others, together. And that's a message I want you to hear loud and clear from my level to Tom's level to the sales reps to the administration team at Insurance Network America. We're in this one together. Well, let's take a step back and get into what this rule is all about. This rule has actually been in the works for about 6 years. But the recent timeline is that in June of 2015, the Department of Labor published a proposed set of regulations to expand the Department of Labor's definition of a fiduciary. In April, they finalized new regulations that expanded definition of the fiduciary as well as new and amended prohibited transaction exemptions. And we're going to get into what all of that means here in a minute. Assuming everything stays as it is, in April of 2017, Phase 1 compliance will be required. And full compliance will be required by January of 2018. So which plans are affected? Which accounts? Well, IRAs, health savings accounts, Archer MSAs, Coverdell educational savings accounts, KEOs, solo plans, 401ks, and any product to be funded with a rollover from one of these plans. So that would be, for example, funding a life insurance product using required minimum distributions. So many people believe that the only thing that this rule affects are IRAs and 401ks, but as you can see, that is absolutely not true. And that's part of why organizations, even the United States Chambers of Commerce, have come out against this rule, because it does have far-reaching effect. Now, we're going to try to stick this meeting into a 30-minute time slot today, allow some time for some questions, so we clearly can't go over all of the rules and all of the impact. So what we're going to try to do today is focus on the accounts that affect most of you on this call. We're going to spend our time talking about the impact to you when you're recommending rollovers from a 401k to an IRA, IRA to IRA direct transfers, and opening new IRA accounts. So let's start at the beginning. Does this rule even impact you? Who is a fiduciary under the new rule? Well, any individual receiving compensation for providing advice that is individualized or specifically directed to a particular plan sponsor, plan participant, IRA owner for consideration in making a retirement investment decision will now be considered a fiduciary. And such decisions can include, but are not limited to, what assets to purchase or sell, and whether to roll over funds from an employer-based plan to an IRA. An important point to make is that today, an investment advisor is already subject to fiduciary standard, whereas a registered rep is subject to a suitability standard, and an insurance-only producer is subject to a suitability standard that is a few steps below that. This new rule brings fiduciary standards to the registered rep and the insurance-only producer, as well as redefining investment advice. So let's start with what is under the current definition. Under ERISA today, there is a 5-pronged definition for investment advice. The 5 prongs to this are: you had to be making investment recommendations on a regular basis with a mutual understanding that that's what you were doing, that the advice that you were giving was the primary basis for the decisions, and they were individualized to the plan's needs. That's the law, the rule, as it stands today. The new rule, the new definition of investment advice includes one-time advice without that regular basis condition. There is no longer a need for a mutual understanding of parties. The advice may address particular investment needs or a particular investment decision, but does not necessarily need to be individualized. The client only needs to receive the advice, and the advice does not need to be the primary basis for the decisions. This is a big bullet. This one is important. Just because they received the advice, even if it wasn't the primary basis for their decision, that advice could be considered under the rule as investment advice. It also expressly revises the definition to cover investment management recommendations. So what does all of this mean to you? Once you are considered to be a fiduciary because you gave such advice, you are subject to the fiduciary standard of care. And the fiduciary standard of care requires that a financial advisor act solely in the client's best interest and must disclose any conflict or potential conflict of interest. Conflict of interest includes variable compensation, pushing the button too fast. Variable compensation, in other words, commissions, bonuses, and incentives. The term variable compensation, by the way, means that depending on the product you are recommending, the compensation varies. Therefore, commissions absolutely fall under that category. All right, so back onto this great big slide that I almost made you read too soon, and I apologize for that. Listen, there was a lot of talk that perhaps the Department of Labor did not understand indexed annuities at all, and that's why they dealt with them so severely under this rule. In other words, put them into the same category as variable annuities and other securities products. But I'm going to tell you right now that the Department of Labor specifically addressed indexed annuities. This slide shows you one of the sections out of the rule. And you can see from your screen that they described exactly what the department expects an advisor to take into consideration when exercising the best standard of care, which means you're going to need to be able to demonstrate that you have a clear understanding of all of these provisions of a product. You're going to have to prove that you took the product training. You're going to have to prove that you looked at the financial strength of the company and that you use this information when comparing the product you recommend to the client compared to other products that might have been available to you at that time. The bottom line is you're going to also have to have this documented. Well, let's just say that all sounds easy. Now you're a fiduciary. So what? The truth is that this rule can and most likely will affect everyone who sells these products. And that's because of this rule right here. When an advisor becomes a fiduciary under this new rule, the advisor's conduct is then governed by the Fiduciary Prohibited Transaction Rules in ERISA and the Internal Revenue Code. And generally speaking, those rules prohibit advisors from receiving payments from third parties, such as insurance commissions, unless you meet the requirements for an exemption. These rules are literally prohibited. But before you panic, the Department of Labor has also provided exemptions which, if their requirements are satisfied, would allow you to receive reasonable compensations. And these exemptions are 8424 and one known as BICE. And we're going to get into both of these in just a minute. Let's talk about 8424 first. 8424 has actually been around for a long time. This new rule simply expanded it, albeit they expanded it by a lot. And in the proposed rules, indexed annuities were included under 8424, but at the last minute, they were moved under the more onerous BICE, which again, we'll discuss further. So for now, what's under the 8424 exemption? Things like fixed annuities, your MIGA products, would be considered under the 8424. So if you meet the following requirements, you could receive commissions. For this, you must acknowledge in writing that you are a fiduciary. You must agree to adhere to the best interest standards of care. Your statements cannot be material misleading, and they do consider the failure to describe a material conflict of interest as misleading. So the failure to disclose bonuses, trips, those sorts of things that might have been part of the decision you made would be considered to be misleading. You must disclose your compensation and again, any potential conflict of interest. Before the sale is finalized, disclosures must be delivered to the IRA owner in writing, and they must acknowledge receipt of the disclosures. And your compensation may be no more than what is reasonable, and you cannot have received any additional financial incentives such as trips, awards, or bonuses. So that means that carriers are going to have to take a look at variable compensation offered to their agents and to marketing organizations. Some carriers, such as Allianz, has a structured bonus compensation level on their preferred platform that says the more you produce, the more you earn. They're having to relook at all of those things to make sure they don't get you into trouble underneath this exemption. Organizations like ours are having to evaluate the extras we provide to you when you write qualified business with us. Now listen, this does not mean we won't be able to host them anymore. It simply means that we're going to have to look at how you qualify and what the primary focus of the trip is. So while most likely incentive trips and things like that will change, just like compensation will change, we don't expect our ability to do things for you will go away. I also want you to know that in talking to all of the carriers that we do business with, each of them has determined that they believe that their current compensation to you is reasonable. Therefore, we don't expect to see a huge shift in how much you're paid. We do think you might see a shift to a little bit more of a trail commission. In other words, maybe paying you a little bit less upfront in the first year and then paying you some more in years that come. So we do expect you may see some of that. You may see some levelized commissions. So, we may see these big bonuses come down a little bit, but your standard commission come up. All of that is still in the works and still under discussion. I think this is a great time to take a step back and make a critical point in all of this. First, I want to remind you of our earlier slide when we talked about the piles of pages to be reviewed, the lawsuits that are likely to reshape the rule, the presidential election, which could also mean significant shifts in priorities. But I also want to say this. We use this image to remind you that as you navigate this new rule over the next year or so, you're in a very maneuverable boat. You have lots of time to wait for some of these things to shake out. Carriers, however, as product manufacturers, are less maneuverable. They're like cruise ships on the water. They can still navigate around these obstacles, but it takes more time. In other words, they're going to have to really spend a lot of time looking at things like product design, compensation structure, distribution models, and because of that, they are heavily at work on this right now. Now, Insurance Network, we're somewhere in between. I like to think of us as we definitely need to chart a course for our future, for ours and for yours. But we have time to work through most of this before we make any major changes. So when you hear us say it's business as usual for now, we don't mean we're not working on this, because we are. And as these lawsuits play out, as our carrier partners make decisions, and as we do, we're going to be bringing you this information every step of the way so that you know what your best next steps are. And again, don't forget, we're in this together, so try not to stress too much. I promise you, a lot can happen between now and January 2018. Well, let's get into some of the guts of this deal. One of the biggest reasons this new rule is going to take so much planning and restructuring relates to what's called the BIC exemption. Originally, it was expected that indexed annuities would be with all of the other financial products sold, the other insurance products sold, I should say, covered under the 8424 exemption. The insurance industry was stunned when the Department of Labor moved fixed indexed annuities instead to the BIC. This exemption has many additional rules on top of those in 8424, the most significant being the requirement that a best interest contract be signed, not by you and your client, but by a financial institution and the client. And that financial institution takes on a lot of responsibility and risk in doing so. So there are 4 alternative versions of this BIC. A full-blown BIC for IRAs and non-ERISA plans, a disclosure BIC for ERISA plans, a streamlined BIC, and a transitional BIC. And what we're going to talk about today, again, trying to focus on things that matter most to you, is this full-blown BIC. This is the one that will be required in 2018, assuming the rule has not changed in the meantime. So the full-blown BIC as it stands is a written contract executed at the time of the policy issuance, so not at the time of the sale. And originally, when the rule first was proposed, this was going to have to be something you had signed before you ever took an app. And fortunately, that was at least the final rule, and it's going to have to be at the time of the policy issuance. And this BIC has to include the definition in terms of fiduciary standard of care, some general disclosures for compensation, conflicts of interest, specific compensation figures upon request, some compliance policies for mitigating any conflicts, some mandatory arbitration language is permitted, but I will tell you this is one of the things that has the industry really unhappy, is that it cannot limit class action rights. In other words, it allows for a private cause of action without any arbitration. And in insurance contracts, most include a right of arbitration first, kind of keeps the attorneys out, keeps attorneys' fees down, and allows for people to come to the table together. And this new rule is expected to bring an awful lot more lawsuits in the future should it stand as it is. You know, it also requires that there are transaction disclosures for each investment focusing on fiduciary standards and conflicts. There is a one-year relief if advising the purchase of the same product. So if you sell a product today and then that client decides to add some additional money 6 months from now, it looks as if they will not have to have a new BIC signed. So that was good news. And then the financial institution is going to have a web page that they develop focusing on the business model and, again, any conflicts. So some work has to be done by the financial institution, which brings me back to this and what I mentioned a minute ago. Who signs the BIC? Well, it's the policyholder, the investor, the client that you went out and met with, and a financial institution, which could be your broker-dealer, the bank, an IRA, or an RIA, an insurance carrier, or if approved by the Department of Labor, an organization like ours can file to become a financial institution. What's interesting about all of this is that this BIC transfers all of the risk to the financial institution signing the document, including the private rights of action by the client in future, including the excise tax penalties for breaches, including the added scrutiny by regulators for a sale that they did not witness. This is what is causing most of the angst in our industry. This is something that has everybody pretty upset. How can a carrier sign this agreement with your client that you did everything in their best interest when they weren't there to see how that sale process went? What does it mean? Well, it means you can expect more supervision by whoever is signing the BIC, because the only way a financial institution can mitigate some of the risk is if they're supervising what you're doing. Whether that be your broker-dealer, your RIA, the insurance carrier, or someone like us, somebody is going to have to be talking to you about your sales process. Somebody is going to have to be making sure that you did your due diligence in your fact-finding. Somebody is going to have to make sure that you disclosed any potential conflict of interest. Now, we believe that we are far more likely to be able to work within a model like that because of our close relationships with our producers and our size. We don't work with thousands of insurance producers. We work with a select group of you, and we get to know you really well. And so we feel like we are very well positioned in this, and in fact, we're very optimistic about our future. So expect some changes, expect some more questions, and expect that whoever is signing this BIC is going to be a little stressed out. Now, here's where I want to take a step back as well. If there's one thing you could do to try to help mitigate some of the impact of the Department of Labor fiduciary rule, it would be to reach out to your legislators. It would be to reach out to those folks in Washington, D.C. that represent you and talk to them about the fact that this part of the rule doesn't make a whole lot of sense. You know, when you talk about this whole best interest standard and you talk about making sure that advisors aren't going out and selling bad products to clients just because they're going to make a whole bunch of money and get a whole bunch of incentives and a whole bunch of bonus and all of those things. You know, it sounds real good on the face of it, but when you don't understand the sales process and when you don't understand what it is that insurance advisors like you do every single day, then you're going to make really poor decisions. And I think that's what's happening here. I think that if you reached out to your legislators and your representatives and you made sure they understood that you're already doing the right thing by your clients, you're already acting in their best interest, and more importantly, these are insurance products not securities, and therefore don't need the added scrutiny covered under the vice, I think that that would be a great message for you, something we're doing with ours, something I recommend you do with yours. Well, assuming the rule stands, in addition to producers and their clients having to deal with a lot more paperwork to complete these new disclosures, what does the future look like? Well, you're going to see products become more streamlined in the fixed annuity space and more creative in the fixed annuity space. Why? Well, because fixed annuities would stay under that BIC requirement, but fixed annuities stay under the 8424. So we're already hearing from a lot of carriers that they are looking very creatively at how to bring more benefit and more value, particularly more income riders, to the fixed annuity space. You should expect that compensation for products will be more levelized amongst carriers and amongst products. Expect that compensation that includes production bonuses is going to have to be modified. And I would tell you too that some of the hybrids, some of these more complex indexes that are out there on some of these products may become less common. Marketing organizations like ours are going to need to be more selective in recruiting producers. We're going to have to hire new employees to assist in training you on best interest standards. Carriers are going to be more selective in contracting producers as they're going to become more concerned about part-time annuity agents who may be less educated and therefore pose more risk. And what we're hearing for those of you who are registered reps is that broker-dealers are most likely no longer going to allow indexed annuity sales to be considered outside business activity, and they may restrict the number of IMOs, organizations like ours, that they allow their registered reps to work with. So please know that we are working hard to make sure that we establish and reestablish very good rapport with the broker-dealers that you work with, to ensure that we're going to be able to work with you going forward. But I will say that we could use your help. Please reach out to your broker-dealer and express your interest in continuing to work with INA. It is sincerely your voice that matters the most in these conversations. Other changes you might see. You're going to need to ask more questions. You're going to have to become more educated on the universe of products available to you. And you're going to need to document, and then document some more. One of the things that we're looking into for you is making sure that if you don't currently have a CRM, a system of tracking the sales process, all of the information that went into the recommendation of a particular product, we're working with some vendors to bring you perhaps some greatly discounted, very solid CRM products. And we should have more information on that to you soon. We're also looking at some new tools, because you can expect this to be the next booming industry. Tools that will be developed to assist you and your clients with product selection and comparisons. Perhaps some online tools that you can walk through and just maybe do some basic input that will spit out for you which of the products in your universe of products might be the best fit based on this client's needs. So again, we are partnering with some quality vendors on this, and we'll be bringing new information to you as we can. So, I know I've covered a lot of information, and I know I've probably gone pretty fast. Please let this be the beginning of our dialogue and not the end of it. Please let this be information that we are just starting to bring to you, and bring your questions to us. I know Tom talked about typing in some questions. We'll see if we can get to some of those today. Some of those we may have to table until we know more. And some of those we may have to table back to your sales rep, depending on how long this webinar takes us today. But I want you to know that because we know that hope is not a strategy, and because both we and our carrier partners are committed to the insurance-only producers as well as the registered reps and the RIA space, because we know each of you needs a partner and a strategy, our message to you And the reason that I asked Tom if I could be the one to deliver this message to you today is so that you could hear directly from me, the Chief Operating Officer of Insurance Network, that we're on top of this, we're ready to navigate it with you. We're in this together. We're going to keep you informed. We are all going to adapt. We will grow and we will succeed. We're not afraid, and we don't want you to be afraid either. Is it different? Yes. Is it a pain? Of course. Is it the first or the last time we've had to adapt to new government regulation? Absolutely not. And so we have a couple of choices here, right? The choice one would be to get really nervous and upset and throw our hat up and say, I'm done. Don't do that. Don't do that. We are in this absolutely with you, and we're not afraid, and we're going to be holding your hand through all of this and helping you navigate it. So my advice to you, as I said in the beginning, don't make any drastic changes. Do a lot of educating, learn as much as you can, but don't go out and make any drastic changes right now. If you are considering becoming securities licensed, I think that's great. I don't think this is going to be the last time we hear the issue of source of funds, but know this, you cannot go out and get your 65 or get your Series 6 and decide that you're going to use them strictly to sell insurance products. Nobody's going to allow that to happen. If you want to get a target on your back, do that. If you decide that you want to venture into the security space, you have to get into the security space. So if you're going to be a registered investment advisor, you better be ready to talk about managed money. So just be aware there's a lot of decisions to be made. You've got plenty of time to make them. So again, I know I went pretty fast. Hopefully it wasn't just too crazy. I put our 800 number up here. You all know that. We only did this for people who work with us today. But I will also turn it back over to Tom and ask you, Tom, did we get any questions out there that you want to throw at me?
Sure, there was a couple. Okay, the first one is someone who's an insurance-only producer. I've heard others say that I should go out and get registered or get my Series 65 and join an RIA. I just did it as well. It's easy to do. Or join an RIA. Do I need to go out and get registered is the question.
Maybe.
And I think you just addressed that.
Yeah, maybe. And I would say that if in fact you want to have a more well-rounded practice, and if in fact you are prepared to offer the other products, not just insurance-only products, but the other products to your clients, then sure, absolutely, I think you should do that. And I would say reach out to us and talk to us about ideas we have about which ones you should partner with. We have seen that some broker-dealers are completely pulling out of the index space. So they don't want to mess around with a product that they aren't in love with to begin with. So the last thing you want to do is partner with a broker-dealer and then find out that they are not going to let you write indexed annuities. So I would be cautionary of that. Ask all the right questions. And again, Tom holds all of those licenses and is a really good resource. So reach out to us if you're thinking about it, and let us help you navigate those decisions, I guess would be my point.
Okay, next question is, will all commissions for insurance products be reduced to reflect smaller upfront with the trail?
Maybe, not necessarily. So, let's just take an advisor who right now is maximizing the Allianz preferred bonus structure. And so they're earning an extra 200 basis points on all of their preferred production on top of the standard compensation. I think that structure has to change. And so we don't really know exactly what that will look like, but it sounds like the carrier is leaning towards bringing that compensation down some and then compensation up for producers who were not necessarily achieving those levels. So in some cases, I would say it's going to go up. In some cases, I'd say it's going to go down. I would say that you may expect to see more of these trail commission options so that it's more similar to what you see in a fee-based practice. We're also hearing that some of the carriers, Allianz included, are looking at offering a fee-based product, a no-commission product, but fees only. So I do expect that you're going to see a lot of changes in the compensation space, but I think that at the end of the year, when you look at your 1099, you're probably not going to see a huge hit.
Okay, there's a couple questions came that they wanted to get a recording of the webinar. They liked the slides. Thank you for that. We will have this up on our website, for sure later today. We did record the webinar, so if you need to hear it again, or share it with others that are in your office that didn't get the chance to log in. And then a next question, Lori, for you is, I think that was it. Let me see what else we have. Just got a couple more in, so bear with me. We have, okay, so if you don't want to be an investment advisor, FIAs will no longer be a product that a life-only agent will be able to offer. Is that correct?
Absolutely not, and I did not say that, and I want to be clear about that. So somebody's going to have to sign the BIC, right? And so that becomes the question and the challenge. I can tell you flat out that we have talked to some of our key insurance carrier partners, and they have indicated to us that as long as we're following some best interest practices, which we will be, that as a preferred shop, they'll be willing to sign the BIC for those producers that meet their criteria. So I don't expect that to be an issue at all. In addition, marketing organizations like ours can file to become a financial institution, and we're exploring that. We're looking at all of the options so that we can sign the BIC. And so yes, somebody's going to have to sign the BIC. Yes, whoever's signing the BIC is going to have some pretty in-depth conversations with you about what you're doing, how you're doing it, just so we're all comfortable. But again, I think one of the beauties, Tom, of what we do with Insurance Network is we work with some of the best advisors in the country. Every time we have an event like we did at the summit last month, our carriers come to us and say, oh my gosh, I have never met such a great group of people. And the thing that I love about the producers we work with is you guys already put your clients' needs first. You're already looking at their best interest. I know that. Tom knows that. We work with great producers. So because we know you really well, because we already work with you really closely, I feel really comfortable with signing a BIC and going into partnership and taking on those risks for the producers that we work with. So no, it is not end of business for somebody who's an insurance-only producer. It is just going to change a little bit.
Okay, looks like that's all the questions I've received thus far, Lori. If we didn't answer your question, or if you want to go deeper on it, if you walk away from this call and something else comes to mind, I just want to say please reach out to us. I did mention that we will have this recording up, but if there's more that comes to mind, I'm sure there will be, and we will do more of this as information develops. But please reach out to us if there's more questions you have, you want to go deeper.
Yeah, watch our newsletter, watch our website, watch for our emails, and then watch for future webinars. I do expect our next update will be sometime in the next couple of weeks as a result of the initial NAFA ruling. NAFA indicated to us this week that they do expect to hear something in the next 10 days. So that'll be our first next step and our first next update. I know that Tom and I have on our calendar right now 6 meetings in the next 6 weeks. all surrounding the Department of Labor and talking to carriers and vendors and partners and broker-dealers and RIAs about what's going on and what their feelings are and what their takes are. So, boy, this is just something that we're going to be on top of. It is our #1 priority right now. And I guess I would just say we're all over it. So we will be in touch with you. But the message I wanted you to get, I'm really disappointed on one side that the final question was, man, if I'm an insurance-only advisor, am I out of business? The message I wanted you to take away from here is, you know, it's not the sky is falling. It is not the end of the world as we know it. It is just a changed world, and we're going to figure out a way to get through it for all of our producers. You know, if you look at Allianz, I think their number was 42% of the business that they write comes from insurance-only producers. They're not walking away from that. I'm sure if you take a look at any of the insurance carriers in this space and ask them what percentage of their business is coming from the insurance-only space, it's probably pretty similar. So it is too big of a market for the carriers, the marketing organizations to just walk away from. So try not to kind of go to that side. I think you're going to be okay.
Great, thank you, Lori. And just to reiterate, you know, part of us doing this is, as much as possible, is we want to communicate proactively to you all on what's going on. If there's questions that come up in the meantime, don't hesitate. Don't wonder if something is a certain way or not. Call us. Let us know. We will help answer any of your questions. If there's something we can answer, we'll certainly tell you that, and we'll find out more. But don't feel for a moment that you're alone on this. Many others are out there wondering what's going on, and we hope to help you all feel confident in the direction we're going.
Yep, sounds good. All right. Well, thank you again for your time today, and I hope you make the absolute best of the rest of it.
Thank you, everyone.